Termination of agency. An agency may come to an end in any of the following ways: by the parties, by agreement, by revocation, by principal, by revocation, by agent. Termination of agency by the parties. Agreement. Agency may be terminated at any time and at any stage by the mutual agreement between the principal and the agent. Revocation by the principal. The principal may revoke the authority of the agent at any time before the agent has exercised his authority to bind the principal, unless the agency is irrevocable. But if the act is begun, the authority can only be revoked subject to any claim which the agent may have for breach of contract. If the agency is coupled with interest, the principal cannot revoke agent's authority to the prejudice of such interest. When the agency is for fixed period, the principal must make compensation to the agent for premature revocation of agency without. Revocation may be expressed or implied from the conduct of the principal. The termination of agent's authority takes effect when it becomes known to the agent, that is for the agent, and revocation by the agent. An agency may also be terminated by an express renunciation by the agent after giving a reasonable notice to the principal. Notice of revocation. Reasonable notice must be given of such revocation or renunciation, otherwise the damage thereby resulting to the principal or the agent, as the case may be, must be made good to the one by the compensation, where there is an express or implied contract for the agency to be continued for a specified period. The principal must make compensation to the agent or the agent to the principal, as the case may be, for any revocation or renunciation without sufficient cause. Implied revocation. Revocation and renunciation may also be implied by the conduct of the principal or agent, respectively. Termination of agency by operation of law. Performance or impossibility. Where the agency is for a particular expiry of time. When the agent is appointed for a fixed period of time, the agency comes to an end after the expiry of that time, even if the work is not completed. Death or insanity. When the agent or the principal dies or becomes of unsound mind, the agency is terminated. Insolvency. The agency automatically gets terminated on insolvency of the principal. Destruction of subject matter. An agency gets terminated when the subject matter of the agent. Principal becoming an alien enemy. When the agent and the principal belong to alien countries, the contract of agency is terminated. Dissolution of a company. When a company, either principal or agent, is dissolved, the agency automatically comes to an end. Irrevocable agency. When an agency cannot be terminated or put an end to, it is said to be irrevocable in agency. An agency where the agency is coupled with interest. Where the agent has himself an interest in the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. This rule applies only if the agency is created for the protection of interest of the agent but does not where the agent has incurred a personal liability. Where an agent incurs a personal liability, principal cannot revoke the agency, leaving the agent exposed to the risk or liability he has already incurred. Where the agent has partly exercised the authority, the principal cannot revoke the authority given to the agent after the authority has been partly exercised.